Hope you're doing well. You are not seeing a ghost. You are seeing Eric Rubenstein, a very good friend of mine. Uh, as many of you know, he is with a company called Advise Healthcare. He is the director of fraud litigation for the organization. He's joining us today in the absence of Stephanie and Christine Hall. And I want to just send a quick shout out to our very good friend Christine, who we know is watching. She is unfortunately right in the path of the latest hurricane that's going to be coming across what appears to be Central Florida. Eric, I know you're not down in Tampa where you normally live. You're up in New Jersey this week, so I know you're going to be safe. Hopefully, your house is still standing when you get back. Um, but I do want to send out one very special um, comment to somebody very quickly. Many of you know Storm Culhan of BC Advantage. He is the editor. Storm created Billing and Coding Advantage magazine around the same time that I started with Peter Cohane, the CMC group back in 2003. And we kind of built our company side by side. I contributed a lot of articles over the years, and I still work with them on the editorial board and things of that nature. Storm is in Western North Carolina, where the devastation from Hurricane Helene uh, impacted the good folks in these areas. Storm shared with me just a heart wrenching email the other day that he was um outside and he heard something that sounded like a freight train. And remember, he's from Australia, so I don't know that they deal with that kind of stuff that we deal with here. And he looked up and it was a tornado. And he ran and dove into his garage. The tornado bounced right in front of his garage, jumped over his house, and hit the hill in the back of his house with his wife and kids in there. Very fortunate that he's alive. Thank God that they're okay. But he has been working with all of the members of his local community. Um, every day he's sharing with me that they continue to pull bodies from the rubble. Folks, please uh, donate to good, worthy charities that are stepping up to the plate to help these storm ravaged areas. Samaritan's Purse, the Red Cross. There's so many wonderful charities where the bulk of the donations go to helping the local members, especially in areas where FEMA has not gotten to them yet and supplies are scarce and people are in desperate need of help. Please keep them in your thoughts and prayers. And we're going to pray for everybody in Florida that y'all come out of this hurricane that's supposed to hit Tuesday or Wednesday ish, that you guys are going to be all right. So, all right, with that said, I get to welcome Terry Fletcher, Scott Kraft, Paul Spencer, and again, Eric Rubenstein to the program. Today, we have a really great episode for you, and I'm really looking forward to having this conversation on a few different topics. And the very first one, I'm going to go to you, Paul, because this one is kind of a debacle. Um, so take it away, and we'll discuss this one as we get going.
Well, thank you, Sean. Those of you who are regular listeners and viewers of the podcast know that I am broadcasting here from my home office in Milwaukee. About 90 miles down the road exists a golem in the form of Epic EMR Systems. Now, this company started with a $70,000 investment way back when. It now has the records of over 300 million people on their platforms. And Judy Faulkner, their CEO, their 81-year-old CEO, is now worth about $8 billion. So it is an enormous company. Over a period of time, as I've lived here in Wisconsin since 2002, their footprint has just gotten bigger in the medical information space to the point where it's impossible not to intersect with them. Unfortunately, and I think all of us who are in healthcare know that when it comes to interoperability and when it comes to the sharing of information, Epic has not particularly been a company that plays well in the sandbox with others as far as information sharing. And this came to a head in the last week and a half when a company called Particle Health sued them in an antitrust case in the Southern District of New York based on a dispute they were having as far as who gets that information and when it's shared. Now, because Epic has never really been a good ambassador for interoperability, and these complaints have come up for years from not only other EMR vendors like Cerner and McKesson, but also companies now like Particle Health and other outside vendors who splice and dice that information for either public health purposes or other types of purposes. In this particular case, Epic and Particle Health went through a company called CareQuality, which is kind of a, they work with a health data, they're a nationwide healthcare data exchange. And those of you who are familiar with MIPS, and one of the big things in order to get a MIPS bonus is to work with a nationwide data exchange or local healthcare data exchange in order to share information, which comes into play in times of, let's say a public health emergency where we have a brand new virus on our shores where public health information needs to be shared at a high volume. Suddenly, Epic cut off Particle Health, and from their side of it, they are basically stating that the information that Particle Health was sharing it with people who really don't have a public health stake in the information, and rather they would rather use it for things such as ambulance chasing and other types of things that come into play. We're all familiar with HIPAA from a compliance standpoint, and how people share PHI is very important. Who gets access to that PHI is very important. When these types of disputes are thrown into the public arena, it just raises my awareness that much more about how some of us are, most of us are really not in control of our health information in a way that we believe we are in control of our health information. It's not as easy as signing a simple waiver when you go into your doctor's office for the first time and saying, I realize that my information can be shared and I'm the only person to have access to it. Now suddenly there are a lot more players on the playing field and a lot more people who want that information. And with each step into the netherworld of sharing, comes a much bigger danger as to what happens when that information goes to the wrong party.
So I'm going to continue with that, Sean, if that's okay.
Yeah, please, let's do it.
Okay, so I will try very hard not to show my conservative bias in politics here. Did I just say that? So here's the problem that we have, and just building on that from a HIPAA compliance standpoint, Paul's right. You can't just think that signing not just a waiver, but a protection in the office is going to protect you. We've had a breach from a VA hospital that there were employees that were just, and you can see me if you are air quoting, they were just interested in our two current vice president candidates' medical history. So they decided to go back and look at their military clinical history. No, you can't do that unless you're a treating physician, you are the one involved in their care, and they've signed that you can have that information. And so that was one. And, there was a concern that they may share it with the world, regardless of what you think you're entitled to, you're not. Another one was there was a report in Charlotte on the most recent local television station. It was reported in May that a woman got treatment for a very sensitive issue, that's all they're saying, at a local doctor's office, only to find out later that someone against whom she had obtained a cease and desist order was working in the same office. And they started looking at her without legitimate reason, looking at her medical records. Turned out that this person was, for lack of a better way to put it, kind of a friend of a boyfriend, then shared that information outside the clinic with somebody that was trying to get custody of her kids. And so it's concerning to me on so many levels that we're really starting to see this. We're seeing, luckily, the Office of Civil Rights, OCR, which is a division of HHS, they're starting to get on top of this as far as HIPAA violations. Not enough. I know Eric can speak to that later, but one of the things also that I've noticed is that remote workers, if you have an Apple Watch or you have Alexa in your house and you're talking about patient information, how many times do you're watching a show on TV or you're talking to your partner or your family and you talk a little too loud and all of a sudden some voice from who knows where says, I didn't quite get that. Can you speak up? Or I can't answer that. Well, there's always Big Brother watching if you use those devices in your house. And we're finding that some of the information for patients, for remote workers, has been shared. And now those patients are getting a Facebook request saying, hey, you might know this person. Would you like to friend them? And so, I mean, it's just, I don't know how we stop these breaches, but there's such a domino effect going on. And there's always been, you can't share with outside entities. But, and I'll throw this over to Eric because I know he's got another conversation, or even Scott. How do you deal with the in-office breaches, the inter-office breaches, the remote workers, the staff that aren't supposed to be looking at records just because they work there?
Yeah, that's a crazy one, Terry. And I'll give you as like a real life example. I was recently with a family member that I took to a doctor's appointment, and they needed a pre-authorization from the insurance. And the receptionist at the front desk, for everyone to hear, provided over the phone, provided the family member's name, date of birth, home address, diagnosis, and the CPT code for the MRI that they needed. All while we were sitting there. And so I got up and I said, hey, you just conducted yourself in a way that is volatile and violative of HIPAA. And they looked at me like I had two heads. And they said, no, we didn't. We didn't share any information. Look, when you sign in, we only have your name. And I said, you just spent 5 minutes on the phone for a pre-authorization where you just gave my family member's full name, date of birth, home address, their diagnosis, and the CPT or HCPCS codes out for everybody to hear. How is that not a HIPAA violation? But, interestingly, back when I was an OIG agent, we did a bunch of cases where organized crime groups were involved in medical identity theft, right? For billing, pump and dump kind of things. And one of the things that was pretty prevalent, similar to what happened with the VA, where they were just kind of looking, but in that same vein, these organized crime groups were identifying who the clerks were in the medical records rooms of the facilities and paying for face sheets. For every 100 face sheets, we'll pay you $1,000. And so when we did some of the search warrants on some of these organized crime groups, these are mostly in the DME space, you can imagine. And so what we would see is just hundreds or thousands of face sheets piled up on the desks. Like, how did these come? And they were coming from hospitals and facilities that were 50, 60, 80 miles away. We were in Brooklyn, New York, and we were finding face sheets from facilities up in Orange County, which is a good 60 miles away. No connection between any of the facilities or the people or anything. And lo and behold, you run the billings and you find all these claims were going out for people that were from the area, right? So, old school HIPAA violations were down to the days where people were snapshotting things and the like, up to today where it's super easy to get into these systems and it's super easy to go and make those queries when you have no legitimate reason for making those queries. The thing to keep in mind also in the HIPAA space is merely because you're all part of the same medical practice, even as a physician, your plenary license to provide medications and diagnostic things does not extend beyond an exclusion of HIPAA. The mere fact that you're in a medical practice does not give you plenary ability to go in and start looking at patient records for patients that are not yours. You're not in a compliance role. You're not in a role where you need to do this. HIPAA is really, the lane is this big.
Yeah.
Well, Sean, when you're doing compliance plans and programs, do you ever have to address the inter-office workings of what you can minimally look at, or if somebody doesn't have, on an as-needed basis, or like Eric mentioned, they really aren't a party to that patient's record? Because I'm not seeing that in compliance plans for HIPAA or privacy anymore.
Yes. So the simple answer is yes. And I think what people need to understand is there's something in HIPAA referred to as the minimum necessary rule. Okay. And when we're talking about the minimum necessary rule, it applies to all protected health information, PHI. And this includes information such as names, birth dates, diagnosis, treatment notes. So there's really just maybe a handful of times where it's acceptable to be able to access information. And I always structure policies on accessing different parts of the patient's medical record based on job function, job roles, and who needs to know what about the patient. Because not everybody in the medical practice has to have access to the clinical notes, but some departments need to have access to demographic information. And Scott, I'm going to come to you in a minute, because for one of our clients that we are serving as the compliance organization for, Scott wrote an incredible memorandum to all of the employees of the organization that I had an opportunity to just kind of proofread. And it was one of those where it made me smile, because the feedback that I gave to Scott was, I don't have anything in this letter that I could change to make it any better than what you actually wrote. And we're going to talk about it because they have a serious issue going on, and we're going to explore that. But there's a couple of things that I want to unpack really quickly, because Eric used the term unauthorized release of patient information, right? And when you were talking about your family member and they were doing the prior authorization and all that kind of stuff, the term unauthorized release actually means it's a breach of patient confidentiality. Unauthorized release is just a nice way of saying what really happened. It was a breach of patient information. And there are consequences when there is a breach. And again, depending on the severity of the breach, the potential consequences could include things such as disciplinary action against the healthcare provider. It could go as far as legal penalties and notifications to the affected patients. So there's a lot to be aware of. But with Terry, you opened the door to something that raises the bar, okay? Because now the Department of Justice is engaged in an active investigation. And this is not a partisan politics thing. This is without politics. This is looking at what transpired within the Veterans Administration, which for a long time the administration has been an absolute disaster. What transpired at the VA with JD Vance and Tim Walz, both vice presidential candidates, is what is referred to as malicious intent. That's the only way it can be explained. And malicious intent is basically the intent to sell, transfer, or use individually identifiable health information, IIHI, for either personal gain, commercial advantage, or malicious harm. And I can assure you, when we're talking about vice presidential candidates and what is going to be one of the most consequential elections of our lifetime at this point right now, and it doesn't matter which side you're on, both sides see this as the most consequential election ever. People accessing these medical records aren't doing it just out of curiosity. They are doing this for political gain. They are doing this maybe for monetary gain to be able to go to the Daily Beast or Politico or Fox or MSNBC or CNN or whoever it may be to claim that they have intimate knowledge of JD Vance's medical record or Tim Walls's medical record, whereby maybe they were treated for something, they were counseled for PTSD, whatever it is. That's malicious intent. And to give you an idea, these carry anywhere from a tier 1 to a tier 3 fine. And a tier 3 fine, which is malicious intent, is a fine of up to $250,000 and up to 10 years in prison. And
You know what's weird, Sean?
Yeah,
That,
please.
and I just wanted to bring this up for those of you that haven't been in healthcare as long as some of us have, and I know some of us are hitting our 40th year. I can't believe I'm saying that out loud. But in the 80s, okay, so prior to 1996, the Health Insurance Affordability and Accountability Act, there was no federal governing rule. There was nothing. So, physicians acted within reason, but there was no defining protected health information. And I remember in the days when it was all about the AIDS virus and how that all of a sudden something came out. I don't even remember what it was, but something came out saying not only do you have to protect it, but you have to store it in a separate place than the medical records because that could really harm a patient because of what we didn't know about that and things like that. But it's interesting that not until 1996, which wasn't that long ago, did we have these rules. And the fact that I just don't see where we can completely make sure that this is protected with the digital advancements I mean, how is AI collecting their information? And I know I'm kind of getting out of, kind
no,
of going off here,
you're
but
actually not, Terry. And
but
Paul, I'm
how are they collecting that?
So, and Paul, I'm going to let you go, but think about this. Last week, the Attorney General for the state of Texas negotiated the first settlement of its kind against a healthcare AI company called Pieces. And Pieces was in 4 Texas hospitals where they were collecting patient data in real time and they were creating these summaries. But the problem was the summaries were a complete inaccuracy of what was transpiring.
Yeah.
And under the Texas Deceptive Marketing Act, they were able to go after Pieces and negotiate a settlement. So, the last thing that I'll say on this, because I think that was such an astute point that you brought up, Terry, is this: AI in healthcare is nothing more than a tool. That's all it is. It is a tool. And it is something that requires human interaction, both at the front end and the back end. Because without it, you get stuff that ChatGPT puts out, which is just crap. It's just crap. So let me pause there. Paul, I'm sorry. I didn't mean to step on what you were saying.
No.
Go ahead, please.
Well, of all the health information that is popular with somebody who has malicious intent, there's nothing like something that is generated about a famous person. And I'm old enough to remember. I mean, we're talking about the 2 current vice presidential candidates. I'm old enough to remember the name Thomas Eagleton. And for those of you who are not old enough, I would invite you to Google that name and find out what happened to him in 1972. But this is exactly why we needed HIPAA, because there is going to be somebody who uses that information for nefarious purposes. I'll remind you that one of the first HIPAA convictions after the statute was enacted was somebody who was working at Mount Sinai Hospital, who was working for the National Enquirer from the medical records department, who was selling them information on celebrities who were coming in for medical treatment to that facility. And he had a nice long rest in a four-walled cement room to think about his actions. So there's no way that you can take away the temptation of that except with a very heavy hammer, and speaking of tools, a hammer is a very useful tool until it hits somebody in the skull, and then it's a misuse of the hammer unless it's being used for justice purposes.
Says you.
Well, I grew up in West Philly, so but the hammer of justice needs to come down, and the sentences need to be toughened and strengthened until something like this stops happening.
Well,
they need
Eric,
to make examples of the people who are doing it.
Yeah, I agree. And Eric, I have a question, since your background is, in this legal, the OIG and all that. What do you recommend? Because I know you consult with practices when they see a medical record that's on a friend of a friend, or if they see a record that really isn't something they need to do their job, but or it's a like Paul was saying, it's a celebrity. They're like, oh, let me take a look. Do you give advice on that for, hey, no, don't be doing that? Because I write policy and compliance plans for people too, but I don't want to say it hasn't occurred to me until all this comes up, but it has, but not to the point where it's so much internal could be abused as well, not just, selling it or sending it out, but just, inquiring minds, like Paul said, the National Enquirer, inquiring minds want to know what do you tell practices, or is it even a conversation?
No, I mean, it often is. It's an interesting point. And what I essentially will tell people is, if it's not yours to see, you shouldn't be looking at it. I mean, it's a simple thing. Interesting. When I was an OIG agent, I would have coworkers who would talk about going to a new doctor or whatever, and they would say, "Yeah, but I'm going to go run them before I go." And I went, "No, you're not. No, you're effing not." Like, the fact that you have certain access to information and data doesn't mean that you get the right to just go in and use that. We had access to a bunch of law enforcement databases. One of them was a common one known as Accurate, right? Plenty of people have Accurate, and we would use Accurate as one of our investigative tools. And I would tell people, I was the administrator for Accurate in our office, and I would say to people, you should go in and run an Accurate report on yourself once a year in the beginning of the year, so that you can see what the report looks like, and then it helps you understand when you're doing an investigation and you're running an Accurate, you can understand what that data is. But you should not be running Accurate on your spouses, your friends. In some states, it's a violation of state law. Federally, for example, if you were to run a criminal history on someone, it's a federal misdemeanor to do that. You're accessing a law enforcement database. It should be no different. The mere fact that a provider's practice may have people in that practice that are of interest from the TMZ, perspective, whatever it may be, it doesn't mean that. I mean, it's a little bit like you have to have some sort of self-policing. Just because there's a jar of cookies on the table and you're hungry doesn't mean that you get to go and stick your hand in every time. It's just one cookie. It's just one cookie. But we look at that from a fraud, waste, abuse perspective with providers. Oftentimes, it's just one upcoded claim, and then it's two, right? So, what we tell practices is, as a general rule of thumb, and we do our compliance programs as well, one of the biggest things that we talk about is staying in your lane. If you're a provider and you have other providers in your group, stay away from that unless you've got something written in your compliance plan that says you get access to these records because you're a QA advisor to the practice, you're the chief compliance officer, something in which you can articulate. And even then, we always say, document the access at the time. Keep a separate compliance communication folder, and it can just be even a running tab of a document. On this date, I accessed this record for this reason, and here's why it comports with the compliance plan and why I looked at it. This is a slippery slope, and you see now OCR, they're kicking up their enforcement, right? And they're looking to actually make a stink about these things because it's time. Having a bunch of laws on the books that no one bothers to enforce, and then when there's a breach, everybody gets up in arms, and it's like, I told you so. If you had done something to begin with. Now, keep in mind also, people who are intent on committing fraud don't care about the rules, right? We see these people all the time. We talk our conversations are with the people that are having a waste, abuse, compliance, or an ignorance issue. It's not about the person who's intent on committing a fraud. The problem is that we have too many instances where the people, it's the golden egg, right? I know that Governor Waltz goes to this VA. I know Senator Vance goes to this, and you just have to fight. You have to fight to not have that happen. And unfortunately, sometimes it gets the best of you. But there has to be a deterrent effect. And since generally the rules don't create a deterrent effect, then we have to go to the next piece. And Sean and I talk about these things all the time. The 3553 factors at sentencing, which is how do you create an environment where you reduce recidivism? Well, we're not going to reduce recidivism by people who don't care about the rules. So the deterrent effect isn't there. Then you just got to punish people. And that's where the punitive factor comes in.
You're on mute, Sean. Well, anyway.
Yes, I am. I was going to say, I know you've been patiently waiting, so go ahead and jump in.
Yeah. So, one of the things I'd say about this, and I think Eric's points are good, most of us are not going to have the chance to look at JD Vance's medical records, even if we wanted to. Like, we don't work in a place where JD Vance is patient. We don't work in a place where Tim Waltz is a patient. But there is a real slippery slope effect here. And so one of the things that Sean had mentioned a little bit earlier about a memo that I had recently written, there's what I would describe as like the favor trading of employment among people within social networks. So what do I mean by that? If I have a friend who works at Ticketmaster, I might say, hey, I sure would love to see Taylor Swift. Can you help me get tickets? And they might have some access pathway that I, as an ordinary person, do not have. My dad was a police officer. Some people would go up to him all the time and say, like, I got a parking ticket, I got a speeding ticket. Can you have somebody look at that? So we trade in favors based on our social networks. And I think where this applies, unfortunately, and more commonly when we think about HIPAA violations is, hey, I've been waiting on these labs for 6 days. I know you work at this hospital. Can you just go in and see if they're available and get them for me? And we all think in some ways our brain says, well, that's a victimless crime. It's different from looking at JD Vance's medical records where there's actual malice potentially. I had a client in New York that had a lot of celebrities owing to their location. And they had told me when I was on site, they were like, well, when somebody comes in to do a UA, we write their name on the thing and they go into the bathroom and they leave it there until we get a chance to go in there and we get it. So I'm like, okay, what you're basically telling me is at some point, another patient could go into this bathroom and see a UA container with a famous person's name on it, right? So those are the more malicious cases, but the favor trading is equally as bad. It's still a HIPAA violation, and it still leads to the slippery slope where we think about the things that we don't know. So one of the things that we talked about when we first started off here was there was, if I remember correctly, some issue related to, some sort of domestic violence or custody issue where people within the periphery of the organization may have just seen it as one person looking up a family member's record, but it was in point of fact much worse. And so when you let these minor violations go and you're not diligent about making that point that, look, even if you say as an employee, I need my own medical records for something, I'm not going to make a request. I'm just going to go in and print everything out, right? Or I'm going to go get these labs or test results for some family member, or my neighbor says, hey, I know you work at this place. You are already on that slippery slope and you're already violating HIPAA. And one of my rules of life across everything except possibly men's soccer is I don't want to be a party where the opposing party is the United States. Like they have a lot more resources than I do. And it's just not, whether you think it's a major violation or a minor violation, it is a violation. And I think we all would look at, as I said before, like the looking up of these records of these candidates and say, well, oh, that poor person's going to get fired. That's a HIPAA violation. But we also have to be thoughtful about how we're using HIPAA or how we're protecting patients' health information as part of our own organizations with people who are just our friends, our neighbors, our family members, our colleagues, and that includes things like, hey, my coworker looks like he's gained a bunch of weight or lost a bunch of weight. I wonder if he's okay. Or, hey, like, I can't see Jim. Jim's not in the office today. Maybe he's sick. Like, I'll just look up his record. The things that we see And these are on par violations with any of the other things that we're talking about.
It reminds me of a story. I was watching a documentary on the famous Hollywood producer Jerry Weintraub, and he was having a conversation with Matt Damon. And Matt Damon, he asked something of Matt Damon that he clearly didn't know. He's like, Jerry, I can't answer that question. I don't have a degree from Harvard. And Jerry Weintraub's answer was, well, do you want one? He goes, what do you mean, do I want one? And Jerry Weintraub said, well, I know a guy. So what Scott is explaining is the I Know a Guy network. We love that because knowing a guy is a shortcut to all of the problems that we have in the world. We just can't use the I Know a Guy network for our own health information or anybody else's. That's not a good recipe for living your life as a free person.
Yeah.
Well, it's a good way to say it. That's a very good way to say it. That's exactly what I meant.
So listen, I think the easy way to tie this one together is to say, listen, you've got to do some research. You've got to engage with compliance professionals in the areas of privacy, security, because I'm telling you, we are seeing more actions right now by the Office for Civil Rights. We're actually seeing some interesting things going on. And I want to be very careful about what I talk about, but there are some very interesting things going on right now beyond just the Office for Civil Rights. And without going down that road and leading in too much, read between the lines, I have a feeling some things are going to come out in 2025 with some investigations, some litigations, things that have been going on over the past year that could have some interesting impact to the regulatory landscape. And I'll leave it just there. All right. Any last comments on the Health Insurance Portability and Accountability Act before we take on what I think to me is an extremely fascinating discussion? And it may just be me. All right. So Terry already said, leave me out of this one. I want nothing to do with it. But I think as we get into it, Terry, you may actually have some comments. Who knows? We'll see. But this, what we're about to talk about, and this is the main reason why I asked Eric to join the program today. Eric and I get an opportunity to constantly talk about crazy things that are going on in the regulatory landscape space, things that are going on in the legal world of healthcare. And before we talk about this case in Florida, it is stemming from what happened on June 28th of this year when the Supreme Court overturned what is referred to as the Chevron deference in a case referred to as Loper Bright Enterprises v. Raimondo. And what happened here is that this decision ended a 40-year practice of the federal courts deferring to agencies like the Centers for Medicare and Medicaid Services, the Office for Civil Rights, all of these other governmental agencies on their interpretations of ambiguous federal laws. And I think, I don't think anybody would disagree with me when we talk about the fact that there's a lot of ambiguity in healthcare. Because if there wasn't, we wouldn't have providers being hit with tens of thousands, hundreds of thousands, millions of dollars in overpayment demands. We wouldn't need organizations like the Unified Program Integrity Contractors or the Recovery Audit Contractors or the SMRCs or the SIUs with the commercial payers, right? We wouldn't have providers being indicted and then having to enter into settlement agreements or deferred prosecution agreements or going to litigation. So there is a ton of ambiguity when it comes to the way that rules and regulations and guidelines are written. So here's what happens, right? In the reversal of the Chevron doctrine, and this was a 6-3 decision. So what happens is the ruling now requires courts to exercise their own judgment to determine if an agency's actions are consistent with the statute and the intent of Congress. Because remember, who is the legislators? Congress. And that means that courts will no longer have to accept agency expertise when reviewing challenged regulations. And I think we're going to see a lot of things going on here in the very near future. So, Eric, let me pause, and I want you to jump in here and let's talk about this Florida case, because I think people's minds are going to go when it comes to statistical sampling.
So the one thing that's interesting is that this ruling came out in June, and I think I read an article a couple of weeks ago that said there's already been in excess of 120 or 130 filings as a result of this, right? Because previously judges would just defer to whatever policy, and the policy, by the way, could come from even something as Office of Counsel to the Inspector General, like an advisory opinion, where there may be the attempt to clarify things. And when you look at advisory opinions, most of them touch upon really two areas. Anti-kickback or Stark are really the main ones, because, right, it's all about arrangements. And OSIG is actually in the unique place to provide an opinion about OSIG versus a lot of other things involving, for example, upcoding services not rendered and the like. But what makes this interesting is Chapter 8 of the Medicare Program Integrity Manual talks about SSOE, Statistical Sampling Overpayment Estimation. And there's a bunch of things within there. For example, when we do our training in the SIU space, we tell our SIU investigators, when we do process improvement and policy things, we say, look, if you're not going to do a statistically valid random sample and you're going to do a probe sample, we say always use 30. And the question that we get is, why 30? Well, because according to Chapter 8 of the PIM, CMS says a probe sample is between 20 and 40. We say 30 for consistency. From an SIU perspective, consistency is the number one most important thing. It is a function of compliance. When you are consistent, you get better results because you have something to lean on when questioned about how did you get to where you are. So the issue involving statistical sampling and overpayment estimation has to do with this premise of net overpayments. You can't just punish someone for something that they did as, for example, an upcoded claim without rewarding them for something that might be considered an undercoded claim, right? And so part of the argument in net overpayments is taking overpayments, underpayments, coming up with what that delta is, and that's what your overpayment is, whether it be statistical or probe, you should be doing that. The problem is that inherently one of the issues has been that zero pay claims have been generally released from the universe of the in that communication. And the problem with that is that most of the time when you look at a billing history and you see a claim is not paid, and it's not from a prepay or a post-pay review of an actual medical record, it is a technical denial, meaning something within the claim itself resulted in a denial, whether it be an NCCI edit, an MUE edit, a plan edit, a mismatch of information from the beneficiary's demographics. Who knows? You need to understand what that is. The problem is that when you rule out a zero pay claim, what if in a review that zero paid claim is actually something that should have been paid, or that from the provider side or the auditor side or the expert side, you make a reasonable articulation, this claim should have been paid and why? And you can see these instances occur when you see claims being denied that are won on appeal, particularly as they go through reconsideration, redetermination, and the ALJ level, right? Because remember that the patient record in the CMS space stays static as it goes through the government side. But on the provider side, you have the ability to introduce additional documents that support the premise of why the claim should have been paid as part of the additional document request process, the ADR process. I'm going through that right now with a client. they went from a 100% denial to an under 10% denial when they got to the ALJ. 120 claims on statistically valid random samples, and then 13 claims in which there were issues in which they did not want to go past the ALJ. I think they had an argument, but they chose not to. So the problem is that when you entirely remove zero paid claims, you skew those results because you're not giving anyone the opportunity to say, hey, this claim was denied, but we have documentation that leads us to believe that in the normal course of an audit, prepay, postpay, we're humans, right? Because analytics will lie to you until proven otherwise. You have to be able to have someone say, no, we don't agree with this because something in the algorithm created a negative inference, meaning that zero pay claim when it shouldn't have been. This is going to be a huge issue because the courts are now leaning towards this as an issue. We saw this now on this one case we talked about in Florida, where the government's position on a zero pay claim was rejected because the government's position was, no, you can only bring in claims that have been paid or partially paid. And their argument is a zero paid claim is not paid or partially paid. It's not paid. And the argument is, well, how do you know? How do you know?
That's right. And this is going to have wide impact on statistical sampling because, again, to your point, Eric, a zero paid claim is still something that has to be taken into consideration with the net paid claims, because we can't just look at overpayments and make a determination that the total amount that the provider was overpaid and the damages to the government are only calculated based on what they consider to be an overpayment. It has to include those claims that the defendant was improperly denied on. And listen, as you were talking, I was doing some research and I actually found something incredible in the state of Florida. 30% of all claims that were submitted in 2023 to insurance companies were closed without any processing of the claim. They were billed by the practice, the hospital, the provider. We'll just call it the provider of services. 30% of those claims were automatically closed without any kind of manual review, automated review, adjudication process, simply closed.
Well, and I'll give you another similar example. We had a law firm reach out to us. They were representing a doctor's group, an emergency room doctors group in the New York City metro area. And they were submitting claims and getting claims denied by the thousands, something like 100,000 claims, 50, some ridiculous number. And what it turned out was that the plan's vendor had an algorithm where all level 4 and level 5 claims coming in from the emergency department were automatically denied. Now, granted, are most people that come into the emergency department at level 4 or level 5? Probably not. Probably a level 3. But there are going to be level 4s and level 5s. Remember that, colloquially, we'd always say, when you go to the emergency room, a level 4, you got to be pretty close to death, and a level 5, you got to be dead, right? And so at the time, there was this algorithm to deny these claims. Now, while I will say, yeah, was there probably a high percentage of claims that were overcoded? The answer is yes, but a broken clock is right twice a day. And an urban trauma hospital is likely going to have a lot of people coming in that are pretty effed up, who might actually need the services that require a level 4, level 5. So to have a blanket algorithm to deny them, you're just creating an environment where, of course, you're going to appeal. Like, why wouldn't I appeal? I mean, we see in things like the CERT and the PERM that there's a 40 or 42% error rate, give or take, right, on E&M. So we know that that's a problem. We know that the Holy Grail would be to create AI that could read a record and make that determination. But that's a subject, E&Ms are subjective, right? An E&M is not an E&M is not an E&M. An internal medicine doctor is going to document an E&M very differently than a gastroenterologist, from an orthopedist, and the like. And so you've got to take that into consideration.
I
But the
say
fact
that
of the
all the
matter-
time, Eric. An
It
E&M
happens
is
all the
not an
time.
E&M.
It is not. And the
No.
fact of the matter is that to rule out a zero pay claim when you are going to argue. So look, if you're involved in fraud, if the claim gets paid, great. If it doesn't get paid, you're not fighting it. You're committing fraud. You don't care, right? You're pumping, you're dumping, you're trying to move out of your dirt lot or your mom's basement to get out to where you need to go. But the point of it is that in the general world, if you're a legitimate provider and you submit a claim, you expect to get paid on that claim. And when that claim is denied and you then get an audit in which there's a statistical sample because of something, whether you want to call it a credible allegation for whatever it may be, and you want to fight this, you have to be able to have that in your wheelhouse to articulate. Always remember that in the CMS world of a credible allegation of fraud, it only needs a minimum of 5 substantiated claims, and substantiated is going to be subjective. If you submitted documentation for 5 and you've got 5 beneficiaries that the UPIC is saying, where the bennies are saying, I didn't get this service, I don't know this provider, I don't know this, you are putting yourself in the position where you might have that suspension. Now there's going to be statistical sampling, there's going to be all of that. The zero paid claim piece, while we're talking about it today, I think a year from now, it's going to be a moot point. CMS is going to have to update the PIM.
Yep.
And they're going to have to be a little bit more clear, because it's not really clear. How does a zero paid claim fit in? The Florida lawsuit really does bring up the fact that there is a lot of either diversity or divergence or opinions about the fact that a zero paid claim, technically it is not considered a partially paid claim, right? It wasn't paid, but it's part of the billing universe.
That is right.
And if you really want to take issue with the fact, and we see this when we get to cases that go up through the ALJ, where there is no longer a high sustained error rate to support continuing a suspension or a prepay. You've got to take that into effect.
And remember, a higher sustained error rate, according to Chapter 8 of the Program Integrity Manual, I think it's 8.4, is greater than 50%.
50%.
It's greater than 50%. And I love this case. I got an opportunity to do an administrative law judge case a couple of weeks ago where it was really interesting because the UPIC actually showed up and it was a debacle for them. The 2 individuals from the UPIC who showed up, neither one of them were part of the original investigation. The other one did not perform the actual audit. They had not reviewed any of the case material prior to their showing up, and it was just a complete waste of time. But the most incredible thing for me was they had their statistician show up, and he's a Russian guy, and the judge said, "Why are you here?" And he said, "I don't know. I'm here because statistical questions may come up." And my comment was, listen, Your Honor, there are no questions regarding the validity of the statistical sample. What I have a problem with is the fact that it was done in the following manner. And you need to look at this because you cannot just solely give deference to the UPIC. Here's our issues. They've done a Monte Carlo sample, which doesn't tell me anything other than the fact that it confirms that the outcome that they're telling us exists is right. But there's no, a t-test. There's no Cochrane's theory. There was nothing that was deployed to test the actual samples. Long story short, the judge was like, you know what? I understand this is more than what I want to deal with right now. And we actually wound up taking it from a telephonic hearing to an on-the-record review to allow the judge to really look at everything because it was just such a debacle. I think there's so much going on in the regulatory landscape, and I can't wait to talk about this. Eric, I want to bring you back on to the compliance guy because I want to do a daily dose with just you and me. And I want to talk about the fact that the state of Florida, and there's a lot going on in the state of Florida right now with healthcare legislation and cases being overturned, where the Florida federal judge struck down the False Claim Act qui tam provision as unconstitutional based on the appointment clause. I think this is absolutely going to change. Now, I think there's going to be an appeal of this, probably to the 11th Circuit. From there, depending on what the 11th Circuit does, it could, if they uphold the lower court's standing, it could go to the Supreme Court. I would not be surprised. But the fact that we have individuals filing qui tams, prosecuting these cases as private individuals on behalf of the government, these are not appointed individuals. And you got to remember that and I'm hoping my history is right. I think it was the False Claims Act was first signed into law in 1863 as the Lincoln Law. And my date may be a little bit off, but I think I'm right on 1863. This did not become a major law in healthcare until what, maybe 10, 15 years ago? I mean,
well, I think the provision of the qui tam law came out in like maybe the 80s or something like that, but it became a thing.
But we
And look, I
really
think
didn't see the level that we see
Oh,
now
no, of
until
course
about
not. I mean, back in
15 years ago.
Sure. I mean, when you had some, honestly, what really I think came to light a little bit was when some of the statutes involving healthcare fraud came out, because prior to statutes like 18 U.S.C. 1347, 1349, and the like, you were relying upon the False Claims Act, the Criminal False Claims Act, and the conspiracy to commit false claims to 285 and 286. And then, that's where you really saw a difference, because now you can get more granular on that. It's a great argument to make, because there's an argument to be made, and we'll talk about this more, and I know we have to get off because time is running out. But one of the things to consider is the fact that when the U.S. Attorney's Office or DOJ declines a qui tam and private individuals go after it, is there an indirect appointment that comes through? And obviously, none of us are lawyers, but there's certainly an argument to be made that the Department of Justice has abdicated its position and appointed that private citizen through the qui tam provisions of the False Claims Act to be there. And I know there's competing.
Yeah.
I think in Texas there was another ruling that said just the opposite, that the False Claims Act can go on. So it's a huge area, and obviously it is a very large portion of the fraud, waste, abuse continuum that we have to consider.
Absolutely. And as you were talking, it popped into my head who I want to come on that episode. It's going to be Ron Chapman, because he is a Supreme Court attorney, and either him or Saul Weisenberg, because they're both Supreme Court attorneys. And I think it will be outstanding. Maybe we have both of them, because they may have competing, because Saul's in Texas. So it may be really interesting to see, and then have you come on also, because again, as a retired FBI or not FBI, I saw that little thing on LinkedIn the other day that they posted with you in an FBI hat or something. It was kind of weird. It threw me for a minute. I was like, really? What is that about? And then I figured it out. But anyways, we're going to do a daily dose. The daily dose is going to be on, I'm getting questions on that. It will be on Facebook. It will be on X. It will be on YouTube, and it will be on LinkedIn. Stand by later this week, and I'm going to try to get Saul, Ron, and Eric on to do that with me. All right. Before we go, I want to just say this. I am wearing a hat today, not because I had a bad haircut or I'm having a bad hair day. I am wearing this hat today because I want to bring awareness to the Extreme Couture GI Foundation. Randy Couture has become a friend of mine over the last couple of years. If you're not familiar with him, he's a 6-time UFC mixed martial arts world champion in the light heavyweight and heavyweight divisions. He has an incredible charity called the Extreme Couture GI Foundation. You could go to www.xcgif.org. The things that they are doing for the veterans of this country are absolutely incredible. No veteran should be homeless. No veteran should be struggling to put a meal on the table for their families. No veteran should be struggling, period. They've made the sacrifices. Some made the ultimate sacrifices, and we need to do our part to show the appreciation that we get all of these freedoms of the American flag and what they've sacrificed for us and their families. So please go and check out my good friend Randy Couture's website when you get a chance. Don't forget, please keep all of the people in Florida in your thoughts and prayers as this storm is barreling down. They're calling for a Category 4. They're saying this could be as bad, if not maybe even worse than Helene. Don't forget the good people in North Carolina and around this country that need our help and our support. All right, that's going to do it for this episode. Thank you all so much for tuning in, logging on, and hanging out with me. Thank you to Eric Rubenstein for jumping on at the last minute. Terry Fletcher, who had to jump to deal with a client emergency. Paul Spencer, Scott Kraft, Christine Hall, we love you. We know you're watching and listening. Stephanie Allard, keep doing a great job on what you're doing, and we'll see y'all in 2 weeks. So until then, remember, be good to yourself, but more importantly, y'all be good to each other. Take care.